a strange...
Well, it may be that, you know, en route to a match, that your intention was to go to the match, but you don't get there for a particular reason. It may be because disorder is, you know, you engage in this type of offensive behaviour. So it's wide enough to cover that.
If I might, Convener.
Can I just ask you for clarification? I think, are you telling us that we must read 2(3)(a) as part of 2(3) because a regulated football match includes a place at which a match is televised, so that when we're reading whether or not they intended to attend the match, in other words, that means a regulated match. In other words, where it's being televised. That constrains it. It's not just at large.
Well, what you have is clause 2, and it refers to regulated football match, definition and behaviour in relation to the match. And subsection 2 refers to, for the purposes of subsection 1, a person's behaviour is in relation to a regulated football match if it occurs in the ground where the regulated football match is being held, which is common sense, on the day in which it's been held, whilst the person is entering or leaving or trying to enter or leave the ground where the match is being held, or on a journey to or from the regulated football match. Now, where is the...
It's the next bit, isn't it? It's the A to C, where you say references to a regulated foot match include, and then you go on to where a match is televised.
References to a regulated football match include a reference to any place other than domestic premises at which such a match is televised. So that would include attending at a pub to watch the match.
And therefore the journey, sorry, I'm just trying to hope, therefore where you're saying in A, a person may regard as having been on a journey to or from a regulated foot match, whether or not the person attended or intended to attend the match, by that it means where it's actually happening or where it's being shown in a televised thing. So it's narrower than I was reading it originally.
Yeah, well, that's the way I read it. But, of course, ultimately it's a matter for the courts.
I think I've understood that. The others want to come in. You're still on this one, Alison.
Yes. To follow up from that, you've made quite a lot of play of the fact that you've lifted wording from the football banning orders. We heard yesterday from Professor McArdle that there was some concern over how they hadn't been effective as had been hoped they would be, and indeed that he'd been carrying out some research with the government on that. It would be very useful to have that research published as soon as. I understand that it is finished, it's with the government or with the executive. Are you able to comment on that?
I'm not. I know of it, but I'm not able to comment on the date of publication of that. In relation to the wider question about the number of football banning orders, I think the Assistant Chief Constable, Strathclyde Police, this morning said it was something in the region of around about 120-ish in Scotland. What I can say is that we have, as a prosecutor, what we call a designated football procurator fiscal depute, who deals with cases arising from disorder relating to a football match, and is well aware of the power of the courts to impose football banning orders, and will regularly remind courts of that power on conviction. But the point is, I think, to make, is that ultimately it's a matter for the court. They have to determine, in determining sentence, whether or not it's appropriate to impose a football banning order having regard to the offence and the precise terms of the offence for which the person has been convicted.
Before I just want to ask, does any representative football organisations wish to come in on any of the points that have been raised, football banning orders, or what we've now, I think, resolved about whether or not you're intending to go to a match, but it means you're going somewhere to watch it on a screen, not on a domestic premises? It's fine? Okay. No? Does anybody? No. So I want to ask, Hamza, are you on the same line, football banning orders?
I've got one on the same line and one.
You're not allowed to do your other one, because I've got a queue in the other one. So you do your supplementary, and John, are you supplementary in the same line? Right.
It wasn't on the football banning order, but it was on the unintended travel.
That's fine. That's
a little bit more clarification from the Lord Advocate, perhaps, that from my reading of it, I understood it to mean that, say, there was a group of fans from ex-football club travelling to the match on train, and I know you shouldn't use hypothetical examples, very bad of me to do so second day in a row, but nonetheless, travelling to the football match, singing songs that would be an offence under this proposed legislation. Somebody hops on halfway through on the train journey during the stop. Their intention is not even to go to a public screening or a public house or the match, but is to go to town for their shopping, but then decide to join in the chanting. They would be prosecuted under this proposal, or you think there would be grounds to pursue that person?
Well, I mean, everything depends on facts, circumstances, and context. So we need to look at what the intention of the person was, what they were doing, and what the evidence is.
Intention of going to the football match, watch the football match, go to a public screening of it, go somewhere completely separate. Yeah. Then it would or wouldn't be.
Well, I mean, again, it all depends on facts and circumstances. If, for example, as you've had disorder where persons have no intention of attending a football match, but they're travelling to the surrounding area for a football match with the intention of causing disorder, then that would certainly be covered.
Muddled. I thought I'd sorted it out in my head, but now I'm not sorted it out. We'll just have to read it all and think very hard. John, on the same thing about intentions?
A supplemental to Alison McInnes's point about the need to have clarity, and your points earlier about the guidance that was going to be given in relation to the singing of national anthems, and it would be dependent on the circumstances. I'm just going to put this scenario to you. Can you imagine a situation where an individual who finds themselves in a football stadium or in a crowd of Celtic fans, and the same could apply the other way around, and he or she decides to sing the national anthem, God Save the Queen, or circumstances where you see a group of English supporters and an individual decides amongst that crowd to start singing the Flower of Scotland. Would those be the circumstances that you are foreseeing where that person could be prosecuted under Section 1?
I don't think it's right to answer that because it's a hypothetical situation. What you need to do is you need to look at the facts, the circumstances and the context. Let me answer it this way, okay, to give you an extreme example. If someone at an Old Firm match were to leave, say, the Rangers end and run across the pitch and in front of the Celtic fans sing the national anthem, then the context of that maybe, arguably, is criminal, because the intention is to cause public disorder. Whereas if someone were to, before a football, as a rugby player or whatever, sings a national, not a problem. And that's what the guidance makes clear. And I don't want to be drawn into, well, what about this situation or what about that situation? That's why I said that there will be guidance given to chief constables, and it's not about criminalising the example that you've given. It's all about the context in which the behaviour takes place. So I don't think it's helpful in this debate to say, well, I'll give you another example, would that be criminal? Or I'll give you another example, that wouldn't be criminal. What I'm saying is you look at the facts, the circumstances and the context, and you look at the provision in the bill itself, and you take a judgment on the evidence as to whether or not that meets that definition within the Act itself. And if it does, and you've got credible and reliable evidence, then ultimately it's a matter for the courts, and that's what the courts are there to judge.
That was a very short one on the same thing.
Short, minor point, and I think most of us would agree that some of the headlines this morning have been incredibly unhelpful. But what I wanted to do was touch upon the point, and this is probably directed towards Michelle. In circumstances that have been described, it's not just a split-second decision by the police officer. The Crown would be involved, Procurator Fiscals, and then essentially it would be up to the courts. How would the process, could you maybe just walk us through what the process might be?
The process for any offences in the new legislation is really exactly the same as in any other legislation, that the police, if they thought the conduct was sufficient to justify reporting a case under one of the provisions, it would go to the relevant Procurator Fiscal in the jurisdiction where the offence occurred. And the Fiscal then would apply the guidance which Lord Advocate's referred to, which will also be given to Chief Constables. But in addition, prosecutors will have their own guidance. Will apply the facts and circumstances to see if there is sufficient evidence to satisfy whether there's sufficient evidence for the offences. If there is, then proceedings will be initiated, and thereafter, as the Lord Advocate has alluded to, it's entirely a matter for the court to determine whether there is sufficient evidence beyond reasonable doubt for a conviction. So there isn't any different procedure that will apply in relation to this offence as we would take in any other offence.
Just to add to that point, in addition to guidance to Chief Constables on the reporting of these offences, there will also be prosecutorial guidance to prosecutors, procurators fiscal. We don't make that public, but I can assure you that that's routine for any new offence and existing offences. We have a very detailed set of guidance for prosecutors as to when it's appropriate to prosecute and when not to.
I'm going to have to I'm sorry, I'm still struggling with section 2.4a. In that, to me, to say a person may regard it as having been on a journey to or from a regulated football match, whether or not they attended or intended to. How can you intend to go somewhere if you're... How can you be on a journey to or from when you have no intention of going? How can you be on a journey to or from a regulated football match if you have no intention of going?
Well, it's to cover a situation where you've got a group of supporters, for example, who, the vast majority, have tickets for a football match and are intending going to the match. But there's a couple of persons within that group who don't have a ticket for a football match and have no intention to go to the football match because obviously they don't have a ticket. But they're as part of the group, for example, dealing with a hypothetical situation where they're involved in this type of disorderly behaviour. So the argument would be, should that be, or the policy would be, should that be criminalised? As the Act makes it clear, yes, it should be criminalised if they engage in the type of behaviour which is set out, offensive behaviour set out in Clause 1.
Right, I'm just going to leave it and chew this over and move on because it's maybe just been a long day. John, you've got a different line of questioning, followed by Graham, followed by James, all different questions.
Okay, thank you, Davina. It's for you, Lord Advocate, and thank you all for coming along today. It's in relation to Section 1, subparagraph 5. Lord Advocate, if I understood a number of representations we've heard, and I accept I may have misinterpreted them, we've been told that that section already is a breach of the peace. Now, my understanding it is to cover the situation where you perhaps have a single group, a single faction, and the conduct is deemed unreasonable. Can you comment on that? Would that constitute a breach of the peace? Is this a refinement or is it something new, please?
This is Clause 1, subsection 4.
5.
Subsection 5. Well, the definition of breach of the peace is severe enough to cause alarm to ordinary people and threaten serious disturbance to the community. And as I've said, in a number of cases, we've seen defence